So the Mental Capacity Act was written in 2005, but actually came into operation in 2007, October. And it's an act that takes the Human Rights Act, which hopefully most people are familiar with, and says that we have the same expectations even if we're in a care setting. The Mental Capacity Act really only applies to adults, and it defines an adult as someone who's 16 and over. There are issues for younger people, and it can be applied to those people where we're making big decisions for them before 16 that are going to impact on their lives after 16. But generally the rule is an adult is 16. The minute they reach 16, they've got the right to make the same decisions that any other 16-year-old has, regardless of disability, impairment, whatever. The Mental Capacity Act asks us all paid carers and informal carers, to start from a position of assuming that everyone has capacity. So we shouldn't look at someone and say, well, that person's got a learning disability, or that person's old, or that person's got dementia, and therefore they must not be able to make their own decisions. We have to start from a position of saying everyone can make their own decisions. And it's a bit like innocent until proven guilty. Unless we can prove clearly that someone lacks the mental capacity due to an impairment to make a decision, then we should not make a decision for them. Okay. The Act is very clear. Principle number 2 of the Act says we must give people all the information they need to make the decision. So there's nothing in the Act that says if someone's choosing to drink something or eat something that we shouldn't advise them and perhaps even dissuade them from eating something that we know is going to be detrimental to their health. But the Act does also tell us that we shouldn't be enforcing things that either on someone who has capacity to make that decision, or we shouldn't be enforcing things in someone's best interest that is so upsetting to them. But we must ensure that all the advice from the dentist is available to that person in a way that they can understand, to ensure that hopefully they might make the healthy choices that in effect all of us should make. Principle number 3 of the Mental Capacity Act is very clear. People can make an unwise decision because their health and their oral hygiene is in their own hands. However, the Act does allow for those people who, due to their impairment, really can't put that level of information in their head to make an informed choice. And it does say if we need to, we can make a decision for them, but it must be in their best interests. The 5th principle of the Act also talks about the notion of not overdoing it. We all have a view on someone's best interest, and we should come together, either at a meeting or phone, email, whatever it is, and make some sort of judgment and balance that to ensure that we're not being overly restrictive or unnecessarily exposing people to risk. Mental Capacity Act has what it describes as a 2-stage test to assess capacity. The first question is, does that person have some sort of impairment or disturbance in the way their mind works or operates? Classically, I suppose, in this area that we're talking about, a learning disability could meet that requirement. The second bit, though, is does that learning disability actually, is it severe enough, or does it clearly impact on that individual's decision making? If we can't make that case, then we shouldn't even assess someone's capacity. So we have to be very clear, is the disturbance, impairment severe enough? Is it affecting their decision making? And have we got evidence to suggest it's affecting their decision making? If we have, then and only then should we move to an assessment of capacity. Otherwise we end up in quite a prejudicial place of saying anyone with a learning disability must have their capacity assessed. The Act doesn't say that. In fact, that would be unlawful. The Act says if you've got clear reason to that you need to assess someone's capacity, then assess it. If not, you shouldn't be going near it, I suppose. The Act then says if you want to assess capacity, there's 4 steps that each of us makes or takes in terms of making a decision. So boil it down to that. And a person must be able to make each of those 4 steps in the decision-making process to be able to have capacity to make a decision. The first step is, can the person understand the information? So can you, and that goes back to the principle number 2, can you give people the information in a way that is understandable to them? Can they put it in their head and make some sort of sense of it? If you think that they can make enough sense of it, then that's the first step achieved in terms of decision making. Excuse me. If, however, that the person really, you feel, can't understand that information, That's in effect where their decision making is not being effective, and therefore that's where you would actually say they do lack capacity. If the person understands the information, the second step in making a decision is that we have to keep the information in our brains long enough to make a decision. The Act talks about retaining, I suppose you call it remembering. It's only long enough. So if you give someone a piece of information, they keep it in their head and go, see what you're saying, I think this, that's fine. If by the end of the explanation they've forgotten where the start was, then it may be that they lack capacity in that area. And again, they can't proceed to the next step without retaining the information. The third step, and probably the most complex one for most people, is the ability to weigh up or balance information. So I understand the information, I've kept it in my head, what do I do with it now? Well, I've got to make some sort of choice, and choices are always about having at least two options, maybe more. You can, under the Mental Capacity Act, if you think that someone would struggle to consider 5 different options, you can enable them to make a decision by actually saying, well, we're going to, in their best interest, boil down the decisions to, do you want this or that, if you feel that people can then make a choice between those. If someone really can't weigh up that information effectively because their mind doesn't allow them to do that, then again, that might be where someone lacks capacity. The final step in decision making is slightly different in the sense that you understand the information, you keep it in your head long enough, you weigh it up, and then actually you've got to tell someone what you want. You've got to tell them what the decision is. It has to be very clear though, people get a bit confused with that and think that if someone can't speak, they lack capacity. That's not what the Act says at all. It says communicate in any meaningful way. So if you know a wink, a nod, a gesture means yes or no, the Act says that person has capacity. The final point I would make about assessing capacity is, and a caution really, is people might say what they want. It doesn't necessarily mean they do have capacity, because sometimes people confuse the notion that, well, they've said they want that drink, or they've said they want that food, so therefore they have capacity to decide. It is about just checking out they've got enough understanding. You know, the fact that, okay, if you drink that, I know you'll enjoy it, but are you aware that it might not be so good for you? If the person says, yeah, but I still want it, that's capacity. If they lack capacity, then we move on, go back to that position, principle number 4, which is, do we need to make a best interest decision for this person? But we should not overdo our best interest decisions, proportionate to the risks that are in place. Anything we do for someone in their best interests, those decisions that have an impact on that individual must be considered between a range of people, not just one individual. Day-to-day decisions, yeah, that's fine. If we make a decision that might upset someone or might change their lifestyle or their life, we must consult with other people. In Cornwall, what we've identified as a meeting is quite a good forum, or a very good forum, to debate complex issues. Also at that meeting, you might have a range of people who understand the Act very clearly and the principles, and other people who really don't. So it's a good opportunity for people to understand how to make a decision and actually debate the dilemma, I suppose. Equally, we shouldn't have a meeting every 5 minutes. We shouldn't have to have a meeting about every issue. Our suggestion or proposal in Cornwall is that really there's 3 examples of when I would suggest we should have a meeting, or explain why we haven't. One is accommodation moves. So that's long-term accommodation moves, not just a brief move to a hospital. Secondly is serious medical treatment, so treatment that might have an impact on the person's life, either positively or detrimentally, for example, having anaesthetic. And the third one, in our view, should also be if we're making decisions to significant financial decisions that involve the person in engaging in a contract that's going to take a lot of their money, or if we're, for example, recommending that someone go on holiday and much of their savings or their funds will be eaten up by that holiday. If someone doesn't have anyone to represent them, which can be common around certainly medical treatment and accommodation moves, they must be advocated for, and the Act actually allows for that to happen, and it has what is abbreviated to IMCAs, but that stands for Independent Mental Capacity Advocates. So the local authority for whom I work has a statutory duty, must pay for an IMCA service to be available to those people who are going to undergo accommodation moves or serious medical treatment and don't have any friends or family to represent them. In effect, are only represented by paid carers. No dispute that the paid carers might be acting in that person's best interests, but we have to have someone outside to support that person and to represent their wishes. Of course, any meeting or any discussion that takes place, the Act is very clear. Again, we must involve the individual for whom the decision is being made as much as possible. Documentation is critical. If we're assessing someone's capacity, it's not okay under the law just to say they lack capacity. You have to be specific in which circumstance, and you have to show how you work that out. I'm not asking you to write lots of information. Quality is better than quantity. Equally, I would expect, and so would the law, and so would the courts, expect that if we've made a decision in someone's best interests, we can justify it and we can show how we've followed those steps of looking at the whole person and what are they going to gain and what are they going to lose by a decision. So documentation is key in this area. If we are moving to more restrictive practices, again, the documentation needs to be more thorough, and I would suggest clearly available to people. And secondly, it also says that capacity is not static. It doesn't stay still. None of us would be working with people if we didn't hope, I would suggest, or in most cases, we didn't hope that the people would develop skills and develop understanding. Because someone lacked capacity last year to make a decision does not mean this year or this month or this day that that hasn't changed. Otherwise, when we make a judgment, we would in effect be writing that person off from ever being able to make that decision again. And I would suggest that we work with people, certainly in part, to develop their skills, to make their own decisions, to increase their dependence. And that's what the Capacity Act's all about, is supporting people's independence where possible, but keeping them safe when really they cannot decide for themselves.